You could be responsible for all the minimum wage and overtime back pay, all the payroll taxes, all the benefits, everything. Let me tell you something. You cannot afford to get this wrong.
Feel my faith rising. I'm crawling out the trenches, holding me. My life.
Hello, visionaries. Welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. So as you can see, I'm not in my normal setting. I'm not in my office. I am traveling, but I still wanted to make sure that you get this grade A content. And so I've come across a handful of individuals, for-profit and not-for-profit entities that really have a hard time classifying a worker as either an employee or an independent contractor. Some employers misclassify workers because they don't know the law, and other employers do it because they want to avoid legal obligations. On the other hand, if you are an employee that has been misclassified as an independent contractor, you might be missing out on a number of benefits and entitlements afforded to you by the law, such as overtime pay, meal and rest periods, or even workers' compensation benefits. Particularly in California, the misclassification of workers has become a major source of concern for employers after the passing of Assembly Bill 5, which set forth a test known as the ABC test to properly classify the employment status of a hired person by an individual or business. Let me tell you something. You cannot afford to get this wrong. So today I'm going to explain the ABC test to help you ensure the proper classification of your employees or independent contractors. And while proper employment status matters nationwide, the information that I'm giving today will be specific to California law. All right, let's jump right into it. So first, let's define what is an employee. So generally, an employee is a person who works for an employer, and that employer controls the how, where, and when the employee performs its work. So how? Usually indicated through procedures, manuals, processes, systems, and maybe even some type of training. Additionally, as an employee, the employer is typically responsible for ensuring that that employee has the proper tools and equipment to perform the work. So there's a way that employees have been trained to salt the fries at McDonald's. And McDonald's is also providing the potatoes, the salt, the oil, and the fryer. Or there's a way to fold the t-shirts on display at Express. And Express provides the t-shirts, the display, and the folding board. There's a boot camp training when you join the military, and the military issues you gear and uniforms. Training of some sort typically reflects the how and leans toward the classification of an employee. So now let's talk about the where. An employee is typically going to work in a location designated by the employer. So whether it's the physical McDonald's restaurant, the Express clothing store in the mall, an office space, or even being sent on orders to a military base. And now the when. As an employee, typically you have certain working hours. So Katie may work the second shift at McDonald's, or John may work from 9 to 5 at Express. Pretty traditional and intuitive. So now that we've defined an employee, let's discuss what is an independent contractor. So my definition of an independent contractor is a person who is not an employee. Sounds pretty simple, right? Until you get into the gray area. So let's consider some examples. So just based on our loose definitions of an independent contractor and an employee, how would we classify a worker who is employed to handle a 6-month project, but they have to show up at certain locations at specified times, To provide presentations to various groups of people. Not so clear, right? Or what about a job referral agency where someone has a directory of people who are available to work based on predetermined dates and timeframes? How would those people be classified by the referral agency? Better yet, how would those people be classified by the company they get referred to? It's not so clear. So this question became a hot topic based on rideshare companies like Uber and Lyft. Those companies were classifying their drivers as independent contractors, which made them ineligible for certain employee benefits, such as minimum wage, such as meal and rest periods, or even a cap on working hours. So California passed a law implementing the ABC test to help determine whether a worker was an independent contractor or an employee. So let's break down this ABC test and figure it out. Number one, the first factor that we consider is whether a worker is free from the control and direction of the employer. So we can easily refer back to the how, where, and when criteria that we use to gauge the employee status. Do you need to train this person or provide this person with any tools or equipment for them to do their job? Can this worker work for more than one company at a time? Can this worker set their own working hours? Can they hire and pay their own assistants to help them complete the job? These questions are useful indicators to determine whether a worker is free from the direction and control of the employer. If so, then the employer must satisfy the next factor. Number two, is the worker performing work that is outside of the ordinary course of business for the employer? Okay, now this is getting good. Are you a bookkeeper hired to keep the financial records of an e-commerce business? Or are you a cake decorator hired by a bakery to decorate cakes? Which one is it? Independent contractors who provide services in a role that is similar or comparable to an employee will likely be viewed as working in the ordinary course of the employer's business. You better watch yourself. And number three, is the worker customarily engaged in an independently established trade, occupation, or business? So this goes back to, do you have to train the person on how to do their job? Because you should not. An independent contractor does this work for real, not for play. An independent contractor should be in the business of this work already, not starting a business in the future. And how do you know if a contractor is in business? Well, they might have a business entity set up, such as Talbert Law Office, a professional law corporation, or Prime and Paint LLC. They might even have a license of some sort, like an esthetician or a cosmetologist, or even a massage therapist. They might be advertising their services to the public, such as a baker or tax preparer. This is why you should almost never have to train an independent contractor. They should already know what they're doing when you hire them. Now, there are a number of exceptions to the ABC test as well. So the ABC test does not apply to workers in certain industries. There are so many that I will just name a few, just so you know that these exceptions do apply. Among the exceptions are physicians with licenses, dentists, lawyers, accountants, architects, engineers, certain marketing and human resources professionals, and even licensed manicurists and barbers may be exempt if they meet certain requirements, such as setting their own rates. However, although some industries may be exempt from the ABC test, there is another test called the Borello test that may apply. The Borello test is another multi-factor test that helps to determine the employment status of a worker. And just be aware that the Borello test may apply even if the ABC test does not. If you'd like a video explaining the Borello test, let me know in the comments. As a California employer or an employer of California employees, you must also be aware of the reporting requirements. California requires that all employers register as an employer with the California Employment Development Department or the California EDD. Additionally, California requires that all employers, did I say all? All employers must report any new or rehired employees who work in California within 20 days of their first day of work using Form 34. I'll put a link to the form down in the description box. But it doesn't stop there. California employers are also required to report independent contractors within 20 days of either making payments totaling $600 or entering into a contract worth $600 or more within a calendar year. Now, on the federal level, when you're thinking about federal taxes, an employee would receive a Form W-2 for tax purposes, while the independent contractor would receive the Form 1099 for tax purposes from the employer. For instance, if someone hired Talbert Law Office for legal services that totaled more than $600, by January 31st of that following year, they would need to send me a 1099 because I am considered an independent contractor and they hired me for services totaling more than $600. Last but not least, I want to discuss why classification or misclassification of an employment status matters to both an employer and an employee. First, let's talk about why it matters to an employee. Both federal and California law afford certain rights and benefits to employees. As I've mentioned before, those rights include minimum wage, overtime pay, meal and rest periods, workers' compensation benefits, and even non-discrimination and anti-retaliation laws. So a misclassification of an employee causes that employee to really miss out on certain rights and benefits that they're entitled to. Also, as an employee, your federal and state taxes are withheld throughout the year. So more likely than not, an employee will be looking for a tax return as opposed to expecting to pay out taxes. If you are a worker who believes that you've been misclassified, you can file a wage claim with the Labor Commissioner's Office, a report of labor law violation with the Labor Commissioner's Office for a group of workers, or you can file a lawsuit in court. On the other hand, there are reasons why this matters to an employer. Independent contractors are not guaranteed the same protections as employees. For an employer, it costs much more to hire an employee than it does to hire an independent contractor. With an independent contractor, the employer can pay that contractor directly. No payroll taxes, no health benefits, no workers' compensation insurance, no withholding of taxes from the contractor's pay, no meal or rest breaks. It's a much simpler process for an employer to hire an independent contractor, and thus the reason for such prevalent misclassifications. But here's the thing. You cannot contract your way out of an employment status. So what I mean by that is you cannot enter into a contract with a worker saying you're an independent contractor just because the contract says it. Under the law, a worker defaults to an employee status unless and until the employer can meet the ABC test or any other applicable test. As an employer, if you misclassify an employee as an independent contractor, you could be responsible for all the minimum wage and overtime back pay, all the payroll taxes, all the benefits, everything. And understand that workers may be considered employees and have protections under California law, even if they are not considered employees or have the same protections under federal law. If you are an employer and you don't want to get caught slipping out here in these employment streets, I have a great resource for you. In the description box below, you will find a worksheet that can help you determine whether your current or next hire should be classified as an employee or an independent contractor. Well, that's all I have for this video. Give it a thumbs up if it was helpful and stop playing your girl. Don't forget to hit that subscribe button and click the notification bell so that you are notified every time I release a new video. As always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.